Good morning. We are greatly honored this morning to have a truly distinguished panel of judges who are retired this morning and serve as mediators and arbitrators in New Jersey and elsewhere. The Honorable Joseph Dickson is a former federal magistrate judge for the United States District Court for the District of New Jersey. He focuses his practice on bringing closure to disputes in a timely and efficient and discreet manner through mediation and arbitration. Judge Dickson maintains a robust ADR practice and is a trusted advisor to clients faced with complex discovery issues, but spends most of his time in ADR. The Honorable Peter Doyne is formerly the assignment judge of the Superior Court of New Jersey, Bergen County, and a distinguished member of the judiciary for 22 years. He co-chairs the firm's alternative dispute resolution and corporate investigation practices. And with over 40 years of legal experience and a decade on the New Jersey Superior Court bench, the Honorable Michael O'Neill is a highly sought-after neutral for complex, high-stakes litigations. Formerly a civil judge for Hunterdon County, specializes in resolving intractable disputes efficiently from multi-insurer coverage battles to sensitive institutional claims. Judge O'Neill specialized in complex insurance coverage while in private practice, and now does much of that in ADR.
I forgot mine.
While I will moderate the discussion this morning and ask the questions, I'm more than happy to take questions from the audience. Just raise your hand and we'll leave that for discussion. For the most part, judges, I will ask the panel, but then I will ask individual judges, and if another judge who I didn't ask has something to say, they can say that as well. I will start asking the panel a question, and I guess we will move, from my left to right, starting with Judge Doyne, Judge O'Neill, and Judge Dickson. As you all made the transition from being on the bench to becoming full-time mediators or arbitrators, what surprised you, or did anything surprise you, Judge Doyne, about the move from being on the bench to being a mediator, arbitrator, private judge?
But first let me say, I don't know why I'm here. I did not realize the concentration, and I've been very appreciative to hear the other speakers and to learn. I'm going to defer to my smarter colleagues to speak to the topics that I'm supposed to speak to today. I'm fairly comfortable speaking about mediation or arbitration more generally. Maybe I've done 1,500 or more in the last 10 years, and maybe 30 of them have concerned themselves solely with insurance coverage. Well, what have I learned? I've learned I need greater patience. I would hope and expect, and do hope and expect, that capable lawyers will be candid with me. And I always invite lawyers to contact me before the mediation, not the arbitration, but the mediation, and review it with me informally so we can discuss it. With regard to the topic that we're concerned with, I must say I think I hold insurance lawyers to a higher level of intellect and knowledge, because that is what the attorneys do. Whereas if you're representing a policyholder, you may not have the same experience or general knowledge as to this topic. And I guess the difference between being on the bench and being a mediator is you don't decide anything. Frankly, it's much easier to be a judge. You try to be cordial, you try to be pleasant, you try to be knowledgeable, and then if the parties don't want to settle it, you resolve the case. That's not an opportunity that's afforded to mediators. So to me, I think that was the most compelling thing I had to learn, is that there's a difference between being a judge and a mediator.
Judge O'Neill?
Yeah, in terms of the transition, I didn't find it to be a difficult transition, and the best explanation I can give for that is I had the ability to prepare, obviously, for my retirement in New Jersey, as all of you know, or New Jersey lawyers anyway, and it's you're required to leave the bench at age 70, so I knew what my end date was, and I knew what I had to prepare for if I wanted to do something after being on the bench. So I had the ability to talk to a number of mediators who had gone before me, so that certainly helped with my transition. But I do agree with Judge Doyne in terms of the practical aspect of the transition. Yeah, you do. It does require more patience, and it does require a different mindset from being a judge, because your job is to be neutral and totally neutral. Not that you aren't trying to be neutral as a judge. You have less time to and less patience, perhaps, with the process when you're a city judge and you have the pressure of trying to settle cases. So I found that part of the transition was challenging to recognize that you've got an obligation to be neutral throughout the process, and you don't have the ability to twist arms, so to speak, by deciding the case or threatening to decide the case.
I agree with both of what they said. But I also say the patience thing, I'm going to start with that first, because it's been 5 years now for me. I've been off the bench. And when I was a magistrate judge, a large part of every day was settlement conferences. I had, because of the nature of my work, I would have a settlement conference at least 3 to 4, if not 5 days a week. And as a judge, after 2 or 3 or 4 hours, we get to a point where I could say, take what they're offering. And a lot of times people would take what they were offering. I wouldn't say it if I didn't think it was appropriate or reasonable. And I also said to individual litigants all the time, nothing is fair about this system. It's not fair. It's business, Sonny. If you get the reference. And but the point is, it has to be reasonable. It has to be reasonable and rational based on the liability and the damages. Somewhere it's got to fit. So I would have a limited amount of time. As a mediator, I came in with the same mindset, and even 5 years later, I kind of still have the mindset. And it's always surprising to me when, after 8 hours, people still can't get any closer. And I go to complain to my senior partners, and they say, aren't they paying you? What do you care? So I have to think about that as a business person. But I still am impatient, and I'll continue it. In terms of how it was different, it was that you need to listen to me. I thought they would, and they listened to me. By the way, let me say this. I was always surprised when they listened to me. Because one day, I'm a practicing lawyer. I had 30 years of trial experience. I appeared in front of Judge Doyne a few times. I never got to appear in front of Judge O'Neill, but we went to law school together, and he basically, as I told him before the conference, all these years later, I remember, because of his kind help, I got a full scholarship for the third year, so thank you. Having said all that, I was surprised that they listened to me, because one day you're a lawyer, and the next day you're a judge. And it was the next day that they started listening to me. So I still actually get that a little bit, and I really appreciate it from all of you practicing attorneys, that you pay the respect to the little mediator, and I appreciate that. But those are the differences, so I agree.
I guess this is to the panel as well, and I'm going to admit that they saw some of the questions before, but not all, and not in the order I'm going to do. But to the panel, and I guess this matters to us in a way. How good are you at predicting if a case will settle? And what tips you off? Like, when we come in the room, do you I'm going to make lunch plans? Or is there something that you can see either from the mediation statements or from the conversations before about whether and how and where it's going to settle. Judge Doyne, I'll go from left to right.
I'm appreciative when I had the opportunity to speak with lawyers before mediation. I'll just do the last 2 days I had. On Wednesday, I had a matter in which there's a purported $500 million loss. And I had written to counsel for the plaintiffs 2 weeks ago and said, this is what I think, boom, 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 boom. If you'd like to chat with me in advance, please let me know. And they said, no, there's no need. And I had set forth, because I'm not as gracious as my colleagues, what I thought might be a reasonable resolution. The night before, I don't know, maybe it was 9 p.m., which is my bedtime, I got a dramatically different demand. That was disillusioning to me. So in response to your question, I then thought there was not a likelihood the matter would resolve. That matter did resolve. Yesterday I had lawyers fighting with one another, and the side I agreed with thought I was a very capable mediator, and the side I disagreed said, Judge, I'm going to teach you how to be a mediator. So you have an idea, but it's certainly not always correct as to what's going to happen.
Judge O'Neill.
Yes, and this will shock you to hear me say it depends. As Judge Joy said, it depends on what you know going in, whether you have a feel for whether the case is going to resolve or not. Lots of times, you know going in. I had one the day before yesterday that the demand was, it was two demands and it was $40 million. Sex abuse of minor claims. And those cases are, as you might imagine, very, very difficult to place valuations on. And the opening offer was $100,000. And I guess I knew going in, because I had read the mediation statements and I had talked to the lawyers in advance. I knew it wasn't going to settle that day. But I thought we'd make more progress than we did, and unfortunately we did not. So, but there are cases where you have a really good sense going in that this is going to resolve. It should resolve. I know the lawyers. I kind of know where they are. It's going to get done. Joe?
And then does it get done?
Sometimes. Depends.
No shock. That's exactly the same feelings I have about this. Some cases I'm absolutely positive will settle, and they don't. Most cases will settle, and I have found, even when I was on the bench, I have found that if I just stay with it long enough and I just keep bringing them in and I keep talking to them, or I call them up after the meet, most cases settle. Some cases you're going to find out just aren't going to settle. I had a civil rights case where I thought needed to settle, and the defendant, which is a county, wanted to settle it. They didn't. It was a racist case. It was a race discrimination case. I don't think it was a racist case. If it was a racist case, they would have definitely settled it. And the plaintiff would not take the more than ample offer on the table, and I begged him to take it. And then we went into court, and I sat with the magistrate judge, and the magistrate judge said, "You got to listen to Judge Dickson, because I agree with him. You need to take this money." He didn't take it. So sometimes they just won't settle. That case went to trial. No, that case went to summary judgment, and Judge Arleo threw it out. Wow. So the guy could have made a few $100,000, and he got nothing.
Hey, one thing I'd like to add, with Steve's permission, as I've done this longer and longer, some of these cases can't get resolved the first day. They have to come back in a week or a month. And from my perspective, I'm always very open to that and appreciative if you tell me that sometime during the day. Otherwise, I look at it as my responsibility to try to resolve that case that day. And all of us have somewhat talked about patience. Mine is probably the thinnest. But if we know that, Judge, I'm going to have to speak to my carrier, or I have to go before a board, or I have to do X, Y, and Z, please don't get impatient. Let's do as much as we can today, get as close as we can today, and then, Judge, we hope we can come back in a month. That's perfect as far as I'm concerned, and frankly, I appreciate it because it sort of gives me a heads up, and I don't have to get as agitated.
I think from my perspective, more and more the cases settle after, and I spend hours on the phone with Judge O'Neill, and when he calls me, I like to be in a public place so I can say on the phone, "Hi, Judge." My kid's like, "It must be important." Yeah, a little. But I think it does have, that one day, maybe not enough. I think in the past, maybe it was, but it seems to be that now it takes more time to germinate and for people to figure out what they want to do. You did mention, Judge O'Neill, about mediation statements. I want to ask the whole panel again. What do you want to see in mediation statements? What do you not want to see in mediation statements? Do you want them to be exchanged amongst the parties or private? If I'm given the choice, I like them to be private. I don't want the other side to see. But what do you, Judge Doyne, what do you want to see? What do you don't want to see in them?
I personally prefer more than less. I think the more I know, the greater the likelihood that I'll be able to assist you. I do not direct one way or the other whether they should be confidential or on notice. I'm appreciative, though, when they are on notice, and they can be in two parts. You can have a confidential submission with a submission that's comparable but has different positions in the other one. Now, one of the things I think I wanted to suggest to people who are attending today, not every mediator does things the same way. Some mediators do it by cajoling. Some are cordial and humorous. Some are more difficult. Some are more studious. And I think it's important for counsel to try to figure out what it is you want and then consider your mediator, because I'm not sure we're all the same. But if you're asking me personally, I prefer much more information than less.
I know that Judge Doyne reads the mediation statements, because I've been in mediations where he said, "Steve, that's not what Exhibit 35, line 3 says." And you know that. I go, "I didn't think you were going to read it." Judge O'Neill, what do you want to see in mediation statements or not see? And again, do you have, or is it just case to case on whether they should be exchanged or not?
I prefer that the parties exchange as much information as they're willing to share. I do, particularly in complex cases. I think it just helps the process, just as speaking to the lawyers in advance, which Judge Doyne and Judge Dickson both alluded to, and I do too. I try, in almost every case, I'll have a private conversation with each lawyer before, but I don't get shared mediation submissions. As a matter of routine. They're the exception, not the rule, but more and more I encourage the exchange, particularly in complicated cases. If it's an insurance coverage case or it's a real challenging liability case, the more information the parties are willing to share, I think maximizes the chance of making meaningful progress on day one.
I totally agree with that. It's just, if it's not a complex case, I don't care if they share or not. But if it's a complex case, I don't want to get in the middle of misinterpreting what somebody said. I want them to know exactly what their arguments are, depending on the issue, the subject matter. If it's a complex area of law, or if it's a scientific case, or a trademark or copyright case, a lot of times we'll get to a point where we're going to settle based on somebody changing something about what they've written or said, or put into an advertisement, and somebody else agreeing to that. And there comes a point in time when the attorneys have to talk to each other. But I don't really have anything to deviate from what they said.
Could I just add this? I invite counsel to contact me, and I do so I can get a little better insight. Counsel can, in confidence say, for example, Judge, I'm having a little difficulty with my client. Can you explain this, this, and this? Or Judge, I'm having a little difficulty with my adversary who thinks this and this. Or I'm going to need your help, Judge, with the carrier representative, whatever it may be. It allows us, I think, to try to be more helpful to you with the hope that the mediation is going to be more successful. And I think, and I hope you can trust most mediators, if you tell them something in confidence that he or she will keep it in confidence. The idea is to try to garner as much information as possible to try to figure out how to get the matter resolved.
I'm going to allow myself one 15-second story to set up the next question. Christina, Youssef, and I were at a mediation in front of Judge Gleason, who is a retired judge from the Eastern District of New York. We got into his office at 9 a.m. He sat down and said, Christina, Steve, nice to see you. You know you're going to lose. And I said, I usually don't lose before 9:30. It's only 9 o'clock. So my question to the panel is, how much does the strength of the case matter? Sometimes I find that the mediations are just a Venn diagram of where the numbers intersect. But where do we have a case where some of my clients may say, I want to win the mediation, right? They want you to tell them that they are right about whatever issue, and then the money. So where does that, what's your role as telling the truth to them, your case is strong or weak, and then, or just to try to get the money resolved?
Well, that sort of goes back to my just past comment, that I want to know what the situation is. From my perspective as a mediator, you try to mediate, you try to be friendly, you try to be cooperative. Do I think the facts of the law make a difference? Categorically. And I try to express that to counsel and the clients in the manner in which counsel have hopefully indicated to me will best assist them. But do I think the merits make a difference? Absolutely.
I'm thinking of a case I had involving a breach of contract. This was a real estate transaction, and there was a dispute based upon the contract interpretation as to which party was responsible for a certain tax liability, real estate tax assessment. As I went into the mediation, I developed a pretty strong opinion as to who was right and who was wrong, and so the dilemma, so to speak, was do I weigh in and tell the lawyers candidly what I think, because it's going to tip the scales clearly in favor of one party as opposed to the other. And if I do that, I'm going to perhaps, it might jeopardize whether or not the case is going to settle or not. And ultimately, after some discussion and back and forth and trying to fulfill my obligation as the neutral in the room and trying to encourage the parties just to come to the number on their own, I ended up sharing with both sides my opinion that I really did feel that one side had the upper hand, clearly. And the case didn't settle, and perhaps because of that. I think ultimately it did, or ultimately it will, but it didn't. And if I had been a little bit more cagey about it, I suppose, maybe it would have gotten done that day. Because I know that the party who had the stronger hand wanted to settle. But what they were being offered was not commensurate with what our lawyer thought was what she should be accepting to settle the case. So that was an example where my opinion at the end of the day didn't help resolve the matter, at least not that day.
I have two quick stories to tell about this. And one is that, first of all, I think it may be how we conduct our mediations. And I will tell you that almost never put the attorneys in the room together in the beginning. I always separate them in separate rooms. If I'm doing it by Zoom, as soon as we all come on the Zoom, I separate them into rooms. And I have had cases where I thought that one side was going to absolutely lose the case if he didn't settle it. I don't tell the side with the better argument that, because if I tell them that, then we're never going to get it settled. So, and I have shared, they're going to lose. I got pushed, this is just recently, within the last 6 months, I got big pushback from the attorney saying, well, you don't understand this, this, and this. And we went through it, and I did understand it. And finally, he started to understand that he had a problem. And then he said, well, you have to tell my client. No, he didn't want to tell him. So I said, get your client in here. And we told the client, I told the client, this is why I think you're going to lose. The client did not want to be reasonable after he heard me. It took him, and this is one of those where you had to come back and do it. But the whole basis of the way I do this is based on a lesson I learned when I was a very young attorney. Went into, again, I didn't tell you the other county, but Hudson County. I was in Hudson County, and there was a judge back in the day, I'm talking about 40 years ago, who only settled cases. That's what his job was to do, settlement of cases.
Or tried to settle, since we all know who you're referencing.
We went in before the settlement conference. I was representing a cop who had shot somebody wrongfully, but we had worked out a settlement with the plaintiff's counsel of $125,000. We walked in the door. Before any of us said anything, that judge said, this is $1 million case. Yeah. So the lesson I learned was, shut up until you hear from them. Because we ultimately got that case settled for $250,000. That's a long time ago, and I still remember going, Judge, what are you doing?
Can I have two comments with Judge Hillman's remarks? I think we all have different procedures as to how we start. Do we start together? What do we do if we're together? Do we start separately? And I would never suggest that one is necessarily better than the other. I know what I like to do is bring everyone together. And I would like to go through the case, hopefully in an impartial way, so we don't have to spend a lot of time with whether lawyers know that I've read the file and I'm familiar with it. So rather than conclude at 8 o'clock, maybe you conclude at 6 p.m. But the other one is disclosures. If I think one party is in trouble, I would never tell that lawyer in front of his adversary, you're in deep trouble. Now, by the end of the day, I may do it, but I wouldn't in the beginning. But frankly, I also like to get a flavor for the party that I think has some difficulty, what he, she, or it thinks, and then I can determine how long a day it's going to be, and what I have to do. But again, that's why I like lawyers to call me, because if a lawyer were to say to me, Judge, my client is confident he has an absolute winner. If you don't think we do, one, can you tell me why? But two, I am going to ask you, Judge, to speak with my client. That's fine.
When we speak about insurance coverage, and at least from most of the people in this room, and this is all we do. So when we go to a mediation, and Judge Doyne was mentioning about picking out mediators and who would be the best mediator for that, when we go into a mediation, we don't want to have to explain Carter-Wallace or Byrd, or we expect, judges do this for a living, but that we speak a certain language, and the attorneys that we are against are the same usual suspects all the time. We see the same people day after day after day. So with that background, is there something, I'll ask Judge O'Neill, is there something about an insurance coverage mediation is that's unique or not unique, or something that you treat it differently or have to handle it differently than other types of litigation?
I wouldn't necessarily say insurance coverage mediation is unique, Steve. It's different, obviously, from other types of but but it's not unique. But the benefit that I have as a mediator in mediating insurance coverage cases, one, I obviously have the background, but the lawyers on both sides typically are insurance coverage specialists. You don't normally have an imbalance there, and that's advantageous to me as a mediator, because not only hopefully I don't need to be educated about some of the case law that we're all familiar with, but the adversary lawyer doesn't have to be. Both sides are coming in with a relatively level playing field. So I don't find it to be unique in that respect, but it is different, and it's of course challenging, because insurance coverage issues can be complicated and tough to resolve.
Yeah.
I'll ask this to Judge Doyne. Go ahead.
Well,
If it doesn't require a question,
no. I know my colleagues are smarter than I am. I like to be educated, or because I don't pretend to have encyclopedic knowledge about all areas of the law. And frankly, when I read your submissions, I'll then read the cases. I am generally familiar with the cases. Do I pretend to have encyclopedic knowledge about the case law in New Jersey? I do not. And then if I do New York work, it's an entirely different thing, or Pennsylvania work. But I prefer to be on notice, and then I'll be responsible for doing the homework.
Yeah, I would agree. And I wanted to talk about this insurance coverage. When I was on the bench, I didn't have a big background in insurance coverage. And when I got on the bench, if a case came up and it needed a mediator, I had the advantage of being able to appoint mediators, and I would always go to retired state court judges because I knew, assuming that they had the knowledge of that language. But now that I'm out, I treat it like I did other very complex cases when I was on the bench. Just what Judge Doyne said. I tell the lawyers to educate me. I'll tell you, I don't understand why this exclusion is here instead of in the definitions. You were talking about that before. And then I get educated, and then I feel comfortable enough.
So I'll go back to Judge O'Neill to ask the following question. More and more...
You're the favored son.
He's the chair of the panel.
That's why I see you in the middle.
But I'm asking him because I know he knows the answer to this. More and more in our practice, we have what I would call a two-tiered mediation or a triangle mediation, where we're trying to settle the underlying, and we're trying to settle with the insurance company. Not necessarily that the insurance company is paying, but we have a coverage issue, and we have the liability issue. And so we have three rooms at the mediation. Or how do you prefer that? What are the particular challenges? I mean, I spend every day with Judge O'Neill doing this, so I know he knows the answer. But how do you handle, you're dealing with the insurance coverage issues on one end, and then you're dealing with the underlying negligence or breach on the other end?
Well, for starters, I would prefer that there not be a carrier there with a difference of opinion with respect to its insured and whether or not it was going to provide full coverage or whether it was defending under a reservation of rights. So, but the reality is you have to deal with what's in front of you, and when you do have a tri-party mediation, so to speak, in that regard, it presents certain challenges. One of which, of course, is the importance if the insurer and the insured are not speaking with one voice, which they are not typically, then you've got to be mindful of your obligation to maintain confidentiality with regard to what you're learning from the various participants in the mediation. So it certainly presents additional challenges, but it's manageable. And if you're prepared and if you're well educated by the parties, you typically can navigate the issues. Sometimes you can get the matter resolved, but more often than not, the fact that there is a dispute between the insured and the insurer, it makes it difficult to settle it certainly in one session.
Yeah, absolutely.
Judge Dickson, I'll ask you this question. Have you noticed common mistakes that lawyers make in mediation or coming into mediation?
Only in a minor sense, I'd say. The one mistake is coming in and telling me that they cannot lose the case. And more lawyers than you would think do that. And it's just, I always ask them, did you watch the O.J. Simpson trial? But I have had lawyers do that. So that's a common mistake. The other, and this is a minor mistake, and it happens a lot. I'd be interested to know whether it happens with Judge O'Neill and Judge Doyne. Defense lawyers will write a really good letter, and at the end of the letter, they will say, that is why we are coming today with a no-pay position. You're in mediation. If you're coming with a no-pay position, can you save your adversary some time and deprive me of the fee by by saying you're not going to pay? Because, by the way, that is almost never true. So to me, it's a mistake that you would write that. It makes no sense. Not you, but whoever does that.
I had a question. Not to interrupt.
Yeah, no, please.
To the judges, what happens when the presiding judge takes a close look? Because I had that recently. And
The presiding judge, is that what you said?
whoever's the
Yep.
judge handling the case. And it's, how do you make out? Because I have a case. The first day we didn't settle, we're trying to get another date. Well, I don't know what transpired. A negative ruling comes out. So now we go to the second day with a negative ruling. So I don't know what transpired. Are you cautious about what happens during the mediation to the presiding judge? Or?
Are we circumspect in what we tell a judge?
Yes.
To me, I do a lot of federal mediations. I get appointed by the judges on a lot of federal mediations, and I make it clear to the parties that I know the judge who just appointed me, and depending on, I don't make it clear at the beginning, but at some point I may say to the parties, I'm probably going to talk to Judge Hammer about this case, so that they know. If they object, I don't. If it's a private mediation or something that came out of the state court, I have to be a lot more circumspect about that. And quite frankly, I don't think I've ever gotten a call from a state court judge asking me what happened in the mediation. I don't know. I'm not sure why, or I don't know if you guys get. Sometimes a mediation agreement says I can't talk to anybody.
Well, generally the rule is everything's confidential. I tell lawyers, I will not call a judge. You want a judge to call me, he or she can call me. I'm telling you right now, I'm never going to call a judge. If a judge calls me, and it is not frequent, it is generally, do you think if you have more time you can get it resolved?
Yeah.
Or, what do you need for me to be able to get this done? It's not whose side do you agree with or whose side do you disagree with.
I just agree with him.
It's the judge might say to me as a mediator, how do I help you? If I extend discovery another 90 days, do you think you're going to get it done? Frankly, I don't recall a judge, and I've done quite a few of these, ever asking me, Peter, who's right and who's wrong? Fortunately, because I'd have to think diplomatically what I would say in response to it, because I think in true fairness, it's not what we're supposed to do.
Thank you.
Judge Dickson, you just mentioned something about when party comes with no money. And I think there's nothing more frustrating. As policyholders, I would say 95% of the time we're plaintiffs, and we come and we find out in a $10 million case that the offer is $0 or $100,000. Right. And I always say at that point, you should have just told me. It's fine.
Right.
We're big boys and girls. We can litigate this. It doesn't need to embarrass me or waste our time. How do you handle when that happens? And it usually happens like 3 hours into the mediation, and all of a sudden, one of you judges have to come back sheepishly in my room and say they have $100,000. And how do you handle that, Judge?
If I'm clued into this because of the mediation statement, I actually don't wait the 3 hours. I go and I tell the plaintiff, I'm not going to talk to you yet. I got to go talk to the defendant. And I talk to the defendant, and I'm like, is this really a no-pay case? and I give them a chance to explain and most of the time, they turn out not to be real no-pay cases, but sometimes they are. And when they are, I say, well, then we're done. And I go back and I tell the plaintiff, they're in a no-pay position. I in good conscience, cannot waste your time. So that's how I handle that. If it's truly no pay, and I usually if I find out, I don't think I have ever found out 3 hours into it. I may have found out an hour into it, but then I pull the plug. I pull the plug. I'm like, we're going to mediate or not.
Sure. Go ahead. Yeah, what I'll try to do, and I have gotten I can't remember one where somebody actually put in their mediation statement that, Judge, we have a no-pay case. They might say in so many words, we think it's very defensible, and, but I haven't had that experience. But I have been in situations where the offer is so nominal, and I talked about one a day or two ago, where it's virtually a no-pay case, and that's really problematic. What I try to do there is keep the dialogue going and not give up, particularly if I know that at the end of the day the case should resolve and is likely to be resolved. So I'll try to engage the parties for as long as I can. And one of my pet phrases that I try to say to somebody that is taking what I believe to be an unreasonable position is, at some point in time you got to give the other side something to think about. You're going to have to get realistic here if you want to resolve this matter. And you and I both know it's going to resolve. And then, of course, you have to add to that. I know that I have to get them to give you a demand that you have to think about. But somebody here's got to make the first move. And so that's one of the techniques I try to employ is try to basically encourage them. Are we going to continue to spin wheels here and waste time, or are you going to get serious about trying to resolve the case?
I don't find it that infrequent for counsel to write and say, Judge, we see little merit to the adversary's case, but we'll proceed in good faith. I think lawyers are generally smart enough not to say, Judge, this is a no pay, I don't care what you're going to say. Because then you say, well, why are we going to do it? Now, whether we learn in an hour or 3 hours or how long, but if it truly is a no pay, I think we would all like to know sooner rather than later, or have an attorney say to us, Judge, I'm telling you right now, this is no pay. If you can convince me or you can convince the carrier why it shouldn't be, I'm delighted to hear from you, but I want you, Judge, for the purposes of candor, to know that this is our position. And I have no problem with that because, frankly, I think most of us are not there to make you people pay more money than is going to be productive. If we think it's going to progress so that there's a possibility of success, then we keep working. If we know it's not, I don't think there's a need to continue or to make it a little more tempestuous than is necessary.
This question is about specific about coverage. When is, and I'll ask the panel, insurance coverage disputes, when is the best time to have mediation? Is it right after the complaint? Is it before discovery? Is it after discovery? I mean, I have an opinion on this, and I think that early mediation never works in coverage disputes, except when it does. But I don't think it seems to me that things have to be, when it comes to coverage, discovery is usually not the issue because it's legal issues. But where do you, in your practice, in your ADR practice, see the best time to have these mediations? Again, with respect to insurance coverage disputes. Judge Doyne, I'll start with you.
Well, I think I'll defer to my colleague. I generally leave that up to counsel. If counsel think it can be productive in the beginning, I'll welcome the opportunity. Counsel think we should have some discovery or we should bring summary judgment first, I generally defer to counsel. I don't interfere with that.
Yeah, that would be my answer as well. If the lawyers are coming to you and they're ready to mediate, then obviously they've determined that the time is right. And Judge Doyne mentioned summary judgment motions. Sometimes it's the motion's been filed, which might be a better answer to that might be an ideal time to have a mediation, because now you've got the legal issues have been framed, the briefs have been filed. Sometimes the mediation statement's a summary judgment brief, and that provides an ideal opportunity to resolve a case while the motion is pending. And then you get into the discussion of, well, do you schedule the mediation before oral argument, after oral argument? Do you ask the judge to hear oral argument in reserve? And so those kind of timing issues, again, I would defer to the attorney's office. But those are important considerations that I'm sure you all think about when you go into mediation in a coverage case.
And that's how a judge may get involved. I've had cases in which a judge will have a summary judgment, and he or she might say, Peter, will you mediate this? I had this summary judgment. I said, of course. Then I asked counsel, give me your mediation summary if you want, but definitely give me all your papers on summary judgment, and I'll read it.
Yeah, same answer.
So I've mediated with two panel, and every mediation, I think, that has been successful, this started off with the defendant, who representing the plaintiff, defendant saying, we're not doing anything, here's 20,000 or 50,000 or something of that nature. And then the mediator comes back to me and says, well, they're not willing to provide an offer, but if you make an offer, a demand of such and such, it's probably going to work. So they never get involved in actually providing an offer, and you can't really go from there with it. We're in law school, wherever. You know, there's this process of demand and offer demand, and then it comes in and hits a certain figure. But that never happens in my experience. It always happens. There's a big jump at the end. So I would be interested in knowing how often that occurs.
Judge Dickson?
You're saying the defendant basically has got nothing, and then will offer something that's reasonable? Is that the basis of the question?
It's actually, they don't actually offer anything, but then they come back and they accept your demand. And I remember something I had with you, and that's...
I'm glad you remember it.
But it's a process where they don't tell you where they're going to go.
Well, I find that does happen, and I find it extremely frustrating when I don't know where they're really going to wind up, and they keep saying, "Well, that's just not good enough yet. That's not good enough yet." And I agree with you. It's just a horrible way of conducting a mediation. So, my only response to that is, if we're only there because they have indicated to me that they will put something reasonable on the table. And I may have known what they were talking about, but they did not give me permission to tell you. So I don't know. You know.
Do you want to say that? May I speak, please? I happen to think this is an intriguing issue. What the demands are, what the offers are. I think most of us have come to expect that it's not unreasonable for plaintiffs to make a demand with the understanding they don't expect to get anything near that number. What can be sometimes difficult is if you do have an unreasonable demand, if the carrier wants to respond, all right, we'll offer $5,000. You know, you get a $10 million demand and a $5,000 offer. The question in my mind is that always the best way to do it? Now, of course, from a defense point of view, the answer is, Judge, we're trying to send a message that they have to be reasonable. And that's understandable, and that's appropriate, but at least the question in my mind is, can we do it a little more graciously? I mean, do we have to start off in that manner? Because I think it sometimes... can cause unnecessary division between counsel.
Someone have a question? No? I just want to switch over briefly to arbitration. Obviously, being in court and arbitration differ, but from where you sit as arbitrators and not judges in court, how should a litigator approach the argument or the arbitration differently, if at all, than in an arbitration rather than in a court litigation? Is there a difference in the way you view it? Is the way different the way we should view it? Yeah, Judge Doyne, I'll start with you, just left or right.
Judge, if I pick you, how do you envision you're going to deal with the other two? And I said, Steve, you may pick me. It doesn't make a nickel's worth of difference. I'm going to do what I think is appropriate under the law. Now, that doesn't mean you can't chat with your fellow arbiters privately, but when you're doing the arb, you do the arb. To me, like
my question, and I am flattered and a little bit scared that you remembered that question. And my question at the time was, when you have a party arbitrator, right? I pick a party arbitrator, they pick a party arbitrator, and Judge Doyne sits as the chair or the umpire. And I said, how do you view that? Because if I pick a party arbitrator who's not going to vote for me, that's the last time they'll work, right? So they're obviously, and Judge Doyne, to his credit, felt that they are officers of the court, as it were, and of course would do the right thing. And I guess I am so jaded that I didn't think that was a possible answer.
Well, I will say this. When I started, some of my former colleagues used to say to me, Peter, don't do any arbitrations. Because you rule against someone, you'll never see another case. And I said, oh, come on, that can't be true. There is a germ of truth to that. So it's a perfectly legitimate question that an attorney may expect that the arbiter will rule in his or her favor. You best know your arbiter. That would not work with me.
Judge O'Neill?
Sure.
Arbitration versus court?
Well, first of all, I much prefer mediation. that might not surprise anybody. It's easier, but yeah, arbitration presents its own challenges, as Judge Doyne just pointed out, particularly if you're a party-appointed arbitrator, which I have been. And I've had very limited experience with arbitrations. I've only done a handful of them, but I treat them very much like a bench trial. I mean, you're now the decider. You're not the mediator, and so it's a different animal. You have to have a different mindset. You have to be obviously more concerned about ex-party communications, which are forbidden unless the parties consent to it, which I don't know why they would. So you really do try to keep your distance, and you just try to prepare and make the best call you can. But in my limited experience, and I've only done a handful so far, two in particular, I know that the losing side in both cases was particularly unhappy. So, what are you going to do?
I have had even fewer arbitrations than a handful, okay? And I think probably because that reputation about they're already mad at me is out there, I haven't been chosen. So,
yeah. Well, I've probably done 50 of them. I may even have done more than that. And I must admit it's a bit discouraging to me that some who have lost, I've never seen again. And, okay, I mean, listen, everyone's entitled to choose his or her arbiter or mediator, whatever he or she thinks is in the best interest of the client. But I find that unfortunate.
But if you've done 50, it hasn't exactly harmed your reputation as an arbitrator, Peter.
Well, I don't know what it is.
I mean, is there a mistake? Judge Doyne, I guess you've done the most arbitrations. Is there, and you said it's very much like court, so is there a mistake that litigators do presenting the arbitration because they're treating it like court, or they should view it exactly like they would be if you were in, in your other office in Hackensack?
No, I haven't found mistakes. I do, though, believe there is more flexibility in arbitration than in a court proceeding. And in most of these arbitrations that I do ask for permission to speak to the other side, and it is generally granted. And I don't know, having done chancery work, I don't know, for 10 years, I would always have a conference before trial, and I would gently suggest what I thought might happen, and I think arbitration gives you that ability.
Do you find that there are any unique challenges in arbitrating union grievances as opposed to non-union?
Well, I have one upcoming, as a matter of fact, next month. But no, I can't say that I think there's anything significantly different so far.
Peter, based on your last comment about you'll have a conference with attorneys, I take it from that comment that you have been in arbitrations where you've actually, with the consent of the parties, mediated and perhaps resolved it without having to decide it?
As an arbiter, I always offer to mediate in advance. Always. Now, if they don't want to, that's perfectly acceptable. Now, you need a written waiver to allow you to do it. But I think those of us who were judges for too long, you get to a feel for what you can and should not say. Let's put it that way. And I would think it would be helpful. I have a son who's an attorney, and I used to tell him, when you're at motion day and the judge says he or she need not hear from you, you don't have to speak. and I used to be constantly amazed that when I would tell lawyers, I need not hear from you, how they would insist. And finally I got to the point, I said, listen, if you speak, you can only go downhill. So.
Okay, thank you so much. It's been our honor and privilege to have Judge Doyne, Judge O'Neill, and Judge Dickson with us this morning. The